G'day everyone, and welcome to the third video in week 2 of our course in Legal Ethics and Trust Accounting. This week I'm introducing you in general terms to some of the key overarching sources of rules for legal ethics and some of the institutions that exist in order to make those rules effective. So far we've already met the Legal Profession Act and the Australian Solicitors Conduct Rules. In this third video we're going to hone in much more on actual court work, by looking at the rules of court and the rules of the Australian Bar Association as in force in Queensland. Let's start with the rules of court. The superior courts of record, by which I mean the High Court and the Supreme Court of each state, these courts have an inherent right to control the proceedings in their court. They have an inherent right to make rules or to issue orders, and a failure to follow those orders is known as a contempt. Superior courts of record have an inherent power to punish people for contempt. This is not a power that's set out in a statute anywhere. This is a power handed down in the common law over many centuries. The lower courts, and indeed many tribunals, have now been given equivalent powers, but their powers are a matter of statute. Now, most of the time, if a contempt is going to be committed, it's not usually by a legal practitioner, and so many of the different types of contempt really don't affect us here. But some types of contempt really do. For instance, it is a contempt of court for anyone to insult the court, to behave disrespectfully to the court, or to interrupt court proceedings. This includes practitioners. The thing is, of course, that there is a tension between this rule and the expectation that a practitioner will be robust in their advocacy. Robust advocacy sometimes even includes standing up to the judge. You might object to evidence and the judge might rule against you, and you might hang in there saying something like, "Your Honour, I respectfully press that objection," and then give some further arguments. But if you go too far, if you step beyond robust advocacy and instead you become genuinely insulting, you open yourself up to direct punishment by the court. Traditionally, courts have erred on the side of caution, allowing very robust advocacy, even where that advocacy probably was insulting or disrespectful. They do this in order to maximise the freedom which advocates and therefore litigants have for expressing their submissions. So, for instance, in a case called Lewis and Ogden, a barrister in a criminal trial, when addressing the jury, reminded the jury that they were not bound to accept the judge's summing up on the facts of the case. And the barrister suggested to the jury that the judge had been favouring the prosecution throughout the case. Now, on the face of it, you'd be forgiven for thinking that this was insulting or disrespectful, but the High Court found that it was neither of these things, and essentially found that if an advocate felt that the judge was favouring the other side, the advocate ought to say that to the jury. There are other occasions when lawyers simply have to use language in court which would not be acceptable in much of society. I myself, when cross-examining witnesses, have had to use very profane words, including the word often described as the C-bomb, because those words had been used in the conversations that I was cross-examining about. A case where an advocate was found to have crossed the line was the Legal Services Commissioner against Winning. In that case, a solicitor who was representing a client in a criminal case before a jury made a number of statements, including profanities, where he was criticising the Crown Prosecutor and accusing the Crown Prosecutor of dishonesty. In the same trial, after the judge had refused to allow an objection, the solicitor said, "So Your Honour is seriously ruling that in a criminal trial he's allowed to do that?" The second power which the courts have is the capacity to award costs against the lawyer or the law firm themselves. This occurs if a legal practitioner comes before the court with a case that is embarrassing, that is, a case that has no reasonable prospects of success. This has been defined in a case called DeGiorgio and Dunn No. 2 as a case so lacking in merit or substance as to not be fairly arguable. Now, this doesn't mean that every time an advocate loses, they're likely to face a costs order against them. Advocates are allowed to be wrong, even disastrously wrong, while still bringing a case which is not so lacking in merit or substance as to not be fairly arguable. You see, the case doesn't have to be winnable. For one reason or another, lawyers often find themselves going to court having advised the client that the case is unlikely to succeed. But a case can be not fairly winnable, but still fairly arguable. You see the distinction? If a case is not even fairly arguable, then the advocate is wasting everyone's time, including their own client's time, by bringing the matter to court. It means that the advocate is not making responsible use of the court's processes. And in those circumstances, the court is entirely justified in saying that the burden of a costs order should fall on the practitioner and not on the client. Let's turn now to the bar rules. As you already know, the profession is split into barristers and solicitors. Barristers concentrate almost entirely on courtroom advocacy. They are like specialists, sometimes brought in to argue matters in court. Once upon a time, barristers handled virtually all of the significant matters in court, but nowadays solicitors are taking on more and more of that work. And there's a type of solicitor known as a solicitor advocate. I'm a solicitor advocate. A solicitor advocate often has the same training as a barrister and argues the same matters in the same way, but without being a barrister as such. In the future, who knows if there will even be barristers? Certainly there's a vanishingly small amount of work for junior barristers these days. Barristers are not members of the Queensland Law Society. Instead, they are members of the Bar Association of Queensland, and they don't follow the Australian Solicitors Conduct Rules. Instead, they are bound by the Barristers Conduct Rules. I'm not going to go into those rules in massive depth. We'll refer to them a bit during week 11, which is about advocacy, but in reality, to become a barrister, you'll need to complete bar exams and then the bar practice course, and you'll learn about barristers' ethics in those courses. For our purposes, I want you to know just a couple of things. First, under Rule 16, barristers must be sole practitioners. They can't be part of a firm and they can't be part of a partnership. Barristers do combine into groups known as chambers, which share some basic functions like secretaries and resources, but each barrister operates their own business separately. This is allegedly to preserve their independence, but I haven't noticed a lack of independent advice to clients from solicitors just because solicitors operate in firms. Solicitor advocates can do everything a barrister can do without this restriction. Honestly, I don't see any convincing justification for this rule other than some conservative sense of historical continuity. But be that as it may, barristers are still required by their rules to be sole practitioners. Second, and to me this seems truly ridiculous, barristers cannot do work which is regarded by the Bar Association as solicitors' work. So they can't do conveyancing, they can't administer trusts, they can't undertake probate work, they can't serve documents, they can't undertake any investigative processes, they can't incorporate companies, they can't operate trust accounts. I can't see any sensible reason why barristers ought to be prevented from doing this work. Solicitor advocates do all this stuff, but barristers do not. Third, and this is the important one, barristers have to follow a rule called the cab rank rule. The cab rank rule essentially says that barristers are not allowed to pick and choose their clients. If a barrister is asked to appear in a matter and the client is able to pay their fee, and if the barrister is competent in that area of law, and the barrister is not under a conflict of interest, then the barrister must take the client. A family law barrister can't decide that they'll appear for mothers but not fathers. A criminal law barrister can't decide that they're only going to take matters where they personally believe the offender is not guilty. They can't pick and choose. This means that every person in our society can get the best representation that they can afford, and that judges, not barristers, will sit in judgment. In a case called Rondell and Worsley, Lord Pearce said, "It is easier, pleasanter and more advantageous professionally for barristers to advise, represent, and defend those who are decent and reasonable and likely to succeed in their action or their defence, than those who are unpleasant, unreasonable, disreputable, and have an apparently hopeless case. Yet it would be tragic if our legal system came to provide no reputable defenders, representatives or advisors for the latter, and that would be the inevitable result of allowing barristers to pick and choose their clients. This is the one area where I think the bar rules are genuinely superior to the solicitors' conduct rules. I personally would like to see something a little like the cab rank rule operating on the solicitor's side of the profession, at least in relation to solicitor advocates. If the role of the bar diminishes and the role of solicitor advocates increases, this will only become more important. So what have we learned in this video? Well, we've learned that the courts retain the power to punish people for contempt, and that includes practitioners, but you'd really have to be stepping a long way over the line for this to happen. Second, we've learned that barristers have their own entire set of rules. What I want you to know about those rules at the moment is that barristers must practice as sole practitioners, they must not do work that is regarded as solicitors' work, and they must observe the cab rank rule where they take on suitable clients without picking and choosing. At this point, I've given you the briefest of introductions to the major documents that bind legal practitioners in their professional ethics. But words on paper are just words on paper, unless they're supported by institutions that bring them into effect. In the final video this week, we'll meet the two key institutions, the Legal Services Commission and the Queensland Law Society's Ethics Centre.